Well, that's how we wrap up the bulletin here on The Pulse. For more news, please log on to myjournline.com. My name is Faustina Safo, but I'm not leaving you alone. I'm taking you to Parliament just to monitor key happenings on the floor.
Securing their future and existence were not going to be paid for some time. And even if it was going to be paid, it was going to be paid at a rate much lower than what they agreed when they were buying the bonds. And that the tenor that they were given was going to be extended by significant years. Mr. Speaker, many of those who were affected this way were in the Ghanaian middle class. Overnight, they slammed into penury and they were gnashing their teeth. Mr. Speaker, the most important point, however, is that this was self-inflicted. The mismanagement of the Ghanaian economy began no sooner than when the MPP took over power in 2017. Mr. Speaker, by 2019, or if like 2018, it had become apparent that they were mismanaging the economy. And you could tell so from the budget deficit, which gives an indication of whether there is prudence or there is mismanagement. By 2018, the budget deficits that they inherited has started going up. For 3 consecutive years, between 2018 and 2020, their budget deficit was higher than what they inherited. Mr. Speaker, by 2020, they thought that it was more prudent to borrow and spend money that we didn't have in order to win elections. By 2021, their sins had caught up with them and we were heading for a crash. By the time they adopted the DDEP, Mr. Speaker, they had absolutely no option because that was the only way that the IMF would touch us with a long pole. Number 2, Mr. Speaker, and finally, before I sit, Mr. Speaker, it is Dr. Mahamadou Bawumia, who they touted as the best economist this side of the Sahara, who told us that the exchange rate is the biggest indicator of economic prudence. This was in the same lecture where he said the exchange rate will expose you if the fundamentals are weak. It is the duty of government to manage the exchange rate. So if you mismanage it and your currency crashes, and by that reason your debt balloons, it is your responsibility. You have incurred debt. The reverse has happened. We have managed the exchange rate well. So because of that, we have saved 150 billion Ghana cedis of our debt through enhanced foreign exchange liquidity. Mr. Speaker, between January and this month, close to $4 billion has accrued to this economy through gold exports. That is because now 80% of all small-scale gold that is mined in Ghana must be ceded to a government agency called the Gold Board, previously called the PMMC. That is what has enhanced forex liquidity on the market, because our exchange rate regime is defined by the same principles that we know to be demand and supply. There is adequate foreign exchange on the market. That is why the cedi is strong. So it was their fault that they incurred the debt, and we have done good by reducing the debt through prudent foreign exchange management. So, Mr. Speaker, we have not approbated, we have not reprobated. We have simply stated the facts when we say that the DDEP was their own doing. Nobody put a gun to their head to mismanage the Ghanaian economy. But what we can assure everybody in Ghana is that we will not tread the same path that they worked on. We will learn lessons from what they have done, and we will manage this economy such that the gains that have been made will be sustained over the medium to long term. And finally, Mr. Speaker, nobody has said that global factors don't have an effect on an economy. They do. Since time immemorial, we all know that crude oil price increase on the world market affects the price at the pump. But it was not crude oil prices that resulted in the depreciation of the cedi. It was not crude oil prices that resulted in the DDEP. It was not crude oil prices that resulted in the humongous debt that led to the DDEP. Even as there is global crisis now, fuel price at the pump has reduced 8 times since the beginning of this year under this government. These are facts. So, Mr. Speaker, our friends on the other side should be demanded. Let them take responsibility for their mismanagement. I thank you very much.
Yes, honourable members, I put the question. Honourable members, those in favour of the motion, say aye. Aye. Those against, say no. Honourable members, the ayes have it. The motion is carried. We will now move to the resolution. Or Majority Leader, you want us to consider something else?
No, Mr. Speaker, the Minister is not here, so we want to crave your indulgence for the Minister for Interior to take item 18, the resolution.
Yes, please.
Mr. Speaker, the Majority Leader always boasts that he has his ministers. Where is the Finance Minister? And where is the Deputy Finance Minister? This resolution is very important. And Mr. Speaker, we need the Finance Minister or the Deputy Minister responsible for finance. None of them are in the chamber, and they are both members of Parliament. Mr. Speaker, I don't think we should allow the Minister responsible for Interior to take this resolution. If it is as important as it is, then we should be able to get the Minister responsible for Finance or his deputy to take the resolution in question. So, Mr. Speaker, decline his application to allow the Minister responsible for Interior to do that. He did not even consult anybody. But, Mr. Speaker, I just think that you shouldn't grant his request. Mr. Speaker, the ministers are in the chamber today, just like the minister in charge of government communication. They are here to vote on the judges. That's the reason why they are here. There's no releasing, nothing. That is why they are in the chamber today, to vote for the judges. So, Mr. Speaker, the finance minister is not here, his deputy is not here, and for that matter, we should not take that resolution. The resolution cannot be... Mr. Speaker, if monies are not released to ministers to pay contractors, how can that amount to good prudent management of the economy? How can an official rate of dollar to the cedi be Mr. Speaker, 6 months? In 2017, they have forgotten about the fact that in 2017, when we took over, we had announced that we had arrested the dollar. We had announced 6 months, exactly that time, we had announced it. But now, even 24-hour economy, there is zero, nothing. 24-hour economy, where is your finance minister? Where is your deputy finance minister? Mr. Speaker, rule him out. Don't let the minister take the resolution.
Yes, Honourable Deputy Minority Whip, you are now combining your debate on the motion with your objection to the minister taking the resolution. I think he just wanted a bite, and he's got it. Yes, so Minister for Communication.
Mr. Speaker, Mr. Speaker, you know we are all your sons, but like every father, there are sons that disappoint you. And listening to the Deputy Minority Leader, Mr. Speaker, Chief Whip, Mr. Speaker, he was asking the whereabouts of the Finance Minister and his deputy. Mr. Speaker, those are two of your most prestigious sons who are cleaning the mess that was created, the financial mess that was created by their side. So, Mr. Speaker, you know, it is important that they know that some of your sons are making you proud, while some of your sons, when they speak, Mr. Speaker, you shake your head in disdain. I thank you, Mr. Speaker.
Honourable members, may we move to item 18 on the order paper. I grant the leave for the Minister for Interior to take that item, resolution.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move resolution item number 18 on pages 7 and 8 be moved today. Thank you, Mr. Speaker. Yes, I so move.
Yes. Honorable members.
Mr. Speaker, I second the motion.
Motion for us to adopt resolution number 18 on the order paper, moved and seconded, is for the consideration of the House. It being just a resolution, I'll put the question. Those in favor of the resolution say aye. Aye. Those against the resolution say no. Honorable members, the ayes have it. The resolution is accordingly adopted. Yes.
Right, Honorable Speaker, the report of the Appointments Committee, the 15th report, has been electronically distributed to all members. So I crave your indulgence if we can take item number 12.
I didn't complete my statement when you stood up, so I thought you were going to say something on that. Let me now say that by the adoption of the resolution, this House has approved the indicative debt restructuring terms between the Republic of Ghana, represented by the Minister of Finance, and the participating creditor countries of the Official Creditor Committee, Austria, Belgium, Brazil, Canada, China, the Czech Republic, Denmark, Finland, France, Germany, India, Israel, Italy, Japan, the Netherlands, Norway, Saudi Arabia, South Africa, South Korea, Spain, Sweden, Switzerland, Turkey, the United Kingdom, and the United States of America. Yes. I will now refer to the submission of the Majority Leader that the report has been electronically transmitted to all members, and his request is for us to take it now. Yes, Minority Leader.
Mr. Speaker, the Majority Leader made an application for leave to enable this House proceed with motion number 12. Mr. Speaker, per the rules of this House, this procedural motion can be moved to address an urgent matter that requires our decision. That is why, Mr. Speaker, if you look at the text of the motion, it says, notwithstanding Order 1041, which requires that motion should not be debated until at least 2 sitting days have elapsed after the notice to move the motion is given. Mr. Speaker, you asked some questions. When did the appointment committee finish its work? We finished our work Friday afternoon. This morning, around 11:30, the chair of the committee called members into a meeting at his conference room for us to deliberate. Mr. Speaker, we concluded on the report, and although this side of the House is dissatisfied with your earlier ruling, we have yielded, which ruling has made the report
has made it possible for him to lay the report, and same has been laid. Mr. Speaker, what is the urgency requiring this procedural motion to be moved? At the hearing, the nominees indicated that the current bench is made up of 13. If you even take the Chief Justice who has been suspended out, we have 12. Mr. Speaker, what matter has suddenly arisen, thereby giving rise for the majority leader to push that the report that has just been laid, instead of it going through the normal requirement of 2 sitting days, we should move it today? Is it the case that we do not have sufficient number at the Supreme Court to be empaneled to determine any constitutional issue? Mr. Speaker, this House must be careful in certain precedents it may be setting. We believe that this application is being made in bad faith. There is no such urgent need for us to suspend our rules to allow for the moving of this motion for the adoption of the report. Mr. Speaker, I do not want to believe that there may be something that I don't know. Mr. Speaker, only yesterday, our friends argued that there was no need to rush. Mr. Speaker, in fact, the majority leader is on record to have said that even the nomination of 2 justices to the Supreme Court at the time when some were being expected to retire was too early in the day because the people have not retired. So why was Akufo-Addo's government in a rush? Mr. Speaker, today we are in June. The bench is about going on legal vacation. We know that there is sufficient number of judges at the Supreme Court now to make determinations. Mr. Speaker, the majority is pushing its luck rather too far. Mr. Speaker, it is the interest of democracy to allow this motion to go through the normal process. Mr. Speaker, we have 137-page report. Mr. Speaker, it is just being distributed. I do not think that even on the majority side, all of them have received copies. Mr. Speaker, and even if they have received, I'm not sure all of them have read it. Mr. Speaker, you have been part of this House since 1993. This is a dangerous precedent. This is a dangerous precedent, and it is a reason why they are whipping their ministers to come into the chamber when they are supposed to discharge their ministerial functions. Mr. Speaker, government is not treating the releases to ministries as an urgent matter, but is in a hurry to pass the courts. Mr. Speaker, a moment ago, we were looking for the finance minister and his deputy. We couldn't find them. Another minister had to move a motion in their stead. Can any government minister tell me now that since we approved the 2025 budget, the releases have been made to their ministry? Can any of them say on record, you have become redundant in your ministries? These matters you are not treating urgent, and then judges, just instead of we allowing the report to be read, 2 days. Today is Tuesday. You have today, you have tomorrow, then you can move it on Thursday. That is within the rules. Why are you in a rush? Why are you in a rush? Mr. Speaker, I would pray you that don't be inclined into granting this request by the majority leader. Mr. Speaker, direct the majority leader to the rules so that we thoroughly read the reports before considering saying, Mr. Speaker, I rest my case.
Honorable members, the submission of the minority leader has followed precedent, and this precedent was established in the national interest, so he has just followed that precedent. The motion that is being sought to move is also to follow precedent, which was established in the first parliament, followed in the second, third, fourth, fifth, sixth, seventh, eighth, and we are now in the ninth parliament. And it has all been done in the national interest. So our for presidents in the national interest, we will continue to follow them. That is the ruling I'm giving in this matter. And Order 217, particularly Sub-Rule 11, is very clear. It says the committee shall report to Parliament within 3 days. Within 3 days. After the conclusion of proceedings of the committee when Parliament is sitting. And so the report has been presented to the House within 3 days. That is what our rules say. And I believe that it's proper for us to take it. And so I will grant the permission for the motion to be moved, and then we can move on to the substantive matter. So please, Chair, you may move the motion.
Right, Honorable Speaker, thank you very much for the opportunity to move the motion numbered 12 at page 6 of today's order paper, that notwithstanding the provisions of Order 1041 of the Standing Orders, which requires that a motion shall not be debated until at least 2 sitting days have elapsed after the notice to move the motion is given, the motion for the adoption of the 15th report of the Appointment Committee on His Excellency the President's nomination for appointment as Justices of the Supreme Court of Ghana may be moved today. Mr. Speaker, I so move.
Any seconder? Yes, please.
Mr. Speaker, I second the motion.
Thank you. Honorable members, motion moved and seconded is a procedural motion, so I put the question. Those in favor of the adoption of the motion say aye. Aye. Those against say no. The ayes have it. The motion is carried. We now move to the substantive motion, item 1.3 on the order paper. Chairman of the committee.
Right, Honorable Speaker, I rise to move the motion numbered 13 at page 6 of today's order paper, that this Honorable House adopt the 15th reports of the Appointment Committee on His Excellency the President's nomination for appointment as Justices of the Supreme Court of Ghana. Right, Honorable Speaker, in doing so, I present the Appointment Committee's report. Right, Honorable Speaker, the committee, following your referral on 20th day of May 2025, and after following and complying with the requirement of the law, vetted the law, particularly Standing Order 217 and Article 144, proceeded to vet all the 7 judges. And it is after vetting that the committee's report is being presented for adoption by the House. I first of all urge the entire House to unanimously adopt the committee's report. Mr. Speaker, I also urge on the Hazard Department to capture the entire report as having been read, as I touch on some salient questions that the judges responded to, and then read the conclusion of the report. The Speaker, starting from questions posed to Justice Senyo Jamapwe, he was asked his view on the doctrine of separation of powers, which he answered eloquently. He was also asked the innovations that would improve on justice delivery in Ghana. Another question is about the independence of the judiciary and suppressing of investigative journalism to protect the dignity of the judiciary. The image of the judiciary was also asked on the rule of constitutional interpretation applied by the nominee. Was also asked the importance of cyber security in Ghana's legal education. Another question was reintroduction of the public tribunal system. There was also a question on assets declaration by the judges, deportation of foreign illegal minors, gender parity in the judiciary, extension of retirement age of Supreme Court judges, maintaining judicial ethics, view on spousal property, conflict between foreign and domestic investment laws, modernization of legal education, establishment of Northern Bench, the nexus between the rule of law and economic development, views on justice delay is justice denied, significant judgment of the nominee, reform in legal education, and then the 2015 World Cup, among others, judicial transparency, ECOWAS court issues, issues of democratic theory and constitutional purposes, building trust in the judicial system, judicial ethics, the agency of accountability, among others, were asked. The Speaker, at the end of the day, the recommendation of the committee on him was by a majority decision. As our friends from the minority have voted, all voted against the nominee. The Speaker, the next nominee is Justice Dennis. The Speaker, I must commend him about the scholarly manner in which he lectured the committee. Questions were posed to him about the limited access to legal education in Ghana, diminishing trust in the judiciary, abolition of the death sentence, establishment of separate constitutional courts, human dignity and criminal justice, challenging parliamentary decisions in courts, contribution to children's rights and gender equality, criminalizing child marriage and witchcraft accusations, ensuring gender parity in the judiciary, environmental protection, constitutional amendment, automation of courts, judicial dress code in Ghana's courts, tax obligations, nominees' honorary position, nominees' legal education and qualifications, retirement age for Supreme Court judges, the nominees' view on judicial precedent and legal interpretation, functions of the Judicial Council in appointment of Supreme Court justices under Article 1442. Mr. Speaker, several questions were posed to him, and eloquently he provided the answer. Right Honorable Speaker, third in line is Justice Simon Turibari. Questions were also posed to him on the bribery and corruption in the judiciary, investigative journalism in exposing corruption, proposal for consideration by the Constitutional Review Commission, extension of the retirement age of the Supreme Court judges, partisanship of the composition of the Supreme Court, public disclosure of assets by judges, balancing cultural norms with international regulations, particularly LGBTQ+, achieving gender equity in the judiciary, efforts to empower the youth to pursue legal education, key principles on compensation of victims, establishment of an independent judicial commission, inadequate number of judges in the northern part of Ghana, the reintroduction of the public tribunal system, capping of the number of justices of the Supreme Court, tagging of the judiciary. The Speaker, among others, were posed to the judge nominee. He has also delivered very eloquently. The Speaker, once the Hansard Department will capture the entire report, let me stop by stating the questions posed to Brian Philip. Let me conclude by mentioning the questions posed to Justice Philip Bright Mensah. The first question posed to him was judicial threat, sufficient power in protecting judicial independence, optimum number of the Supreme Court judges, premium placed on judicial service, gun ownership in Ghana, doctrine of separation of powers, recommending judicial reforms, curbing the menace of galamsey, professional obstacles as a judge, among others. Mr. Speaker, the Hansard Department will capture the rest, and I will proceed to read the recommendations and the conclusion of the House. The committee recommends to the House, by majority decision, Mr. Speaker, let me just go straight to the conclusion. Mr. Speaker, in conclusion, the committee, acting in accordance with the provisions of Article 1442 of the 1992 Constitution of the Republic of Ghana and Standing Order 217 of the House, duly examined the 7 nominees submitted by His Excellency the President for appointment to the Supreme Court of Ghana. Upon careful deliberations, the committee notes that all the nominees demonstrated outstanding competence, deep knowledge of the law, and a firm grasp of the judicial ethics. They addressed questions posed by the committee with professionalism, clarity, and intellectual rigor, reflecting their capacity to uphold the independence, integrity, and dignity of the highest court of the land, the Supreme Court for that matter. The committee is satisfied that the nominees possesses the requisite qualifications, judicial temperament, and commitment to constitutional values expected of justices of the Supreme Court. Mr. Speaker, all members of the New Patriotic Party minority were opposed to and voted against all the 7 nominees, the justices of the Supreme Court, on the grounds that, 1, the appointment of 7 new justices was inconsistent with the suspension of the Chief Justice, stating that it was not about filling vacancies but reshaping the constitutional order. As to how this has got to do with the vetting, your guess is as good as mine. Right, Honorable Speaker, the second reason was that the Supreme Court abdicated its constitutional duty and remained silent when fundamental principles of natural justice were being violated. Mr. Speaker, the third is that the NDC had previously proposed the nomination of the 2 justices, citing judicial bloat. And, Mr. Speaker, the minority decision in opposing and voting against all the 7 nominees, the members of the National Democratic Congress majority, however, voted in favor of all the nominees. The committee therefore recommends to the House by majority decision the adoption of this report and the approval of Justice Senyo Jamope, Justice Sir Dennis Dominic Adjei, Justice B.L. Simon Tulibari, Justice Philip Wright Mensah, Justice Gina Pare Ejua Bates Kujo, Justice Hafizata Amaliboba, Justice Kweku Tevia Akabofu. The committee respectfully submits this report for the consideration and approval of the House. Right, Honorable Speaker, I so submit.
Yes, Honorable Member.
Thank you, Mr. Speaker. Mr. Speaker, I rise to reluctantly support the motion. Mr. Speaker, and I would want to second the motion and speak on the points that the minority would want to put across. Mr. Speaker, in seconding the motion, I wouldn't want to go far, but to go to the conclusion of the report. And Mr. Speaker, with your permission, I would want to read the last but 1 page. The committee, acting in accordance with the provisions of Article 1442 of the 1992 Constitution of the Republic of Ghana and Order 217 of the Standing Orders of Parliament, duly examined the 7 nominees submitted by His Excellency the President for appointment to the Supreme Court of Ghana. Upon careful deliberation, the committee notes that all the nominees demonstrated outstanding competence, deep knowledge of the law, and a firm grasp of judicial ethics. They addressed questions posed by the committee with professionalism, clarity, and intellectual rigor, reflecting their capacity to uphold the independence, integrity, and dignity of the highest court of the order. The committee is satisfied that the nominees possess the requisite qualifications judicial temperament, and commitment to constitutional values expected of justices of the Supreme Court. In conclusion, all members of the New Patriotic Party minority were opposed to and voted against the nomination of the justices on the following grounds. Mr. Speaker, the first ground is that the appointment of 7 new justices was inconsistent with the suspension of the Chief Justice, stating that it was not about filling vacancies but reshaping the constitutional order. Mr. Speaker, in this country, and this is important because we as a house, we must develop the jurisprudence of this country. Never in life, Mr. Speaker, ever since I have witnessed that we have had 14 justices of the Supreme Court. This House, Mr. Speaker, and during President Akufo-Addo's era, there were 14 justices of the Supreme Court. Mr. Speaker, some of them left and they were replaced. His Excellency President Akufo-Addo left office with 14 justices. Mr. Speaker, at the last minute, there were 2 justices that were supposed to be promoted to the Supreme Court. Our friends on the other side stood up and said that the 2 justices that were being added were changing Ghana and that we were boosting the Supreme Court and that they opposed that. Here we are, Mr. Speaker. As I have said, it is not that the justices are not incompetent. We have no doubt about their confidence. But, Mr. Speaker, if 2 is flouting the courts, this is the first time we are having 7 justices at a time. And 7 justices at a time, if you have 13 and we add 7, that will make 20. Mr. Speaker, are we redrafting the jurisprudence of this country or the laws of this country? Even though there are laws, and Mr. Speaker, we have never had a ceiling of the Supreme Court judges. But Mr. Speaker, if at this time we don't have any question about raising the judiciary, the bar, the ceiling to 20 and more, then, Mr. Speaker, it's about time that we redraft this in the Constitution. This is why we oppose to that. That if the other side can oppose to 2 being added to the judiciary, the Supreme Court, then 7 must not be allowed. Or else, even if the current Chief Justice is not part of it, then we would have 19, Mr. Speaker. This is unprecedented. It has never happened in the country of this country. This is our point, and this must not be allowed. I would not be surprised if tomorrow the other side would come with a proposal and flood the courts to a number that we cannot mention. To the extent that they have reached 20, now they can go to the extent of raising up to 30. So on this basis, Mr. Speaker, even though we have recognized what the judiciary, these special judges that have been brought before this House, their performance, and I've had direct contact with some of them. For instance, said Denis Ajay, I was in the same office with him, and I know his competence. For instance, even though Sir Justice Mensah is my junior, I practiced before him when he was a circuit court judge in Kumasi. Justice Turubaru, Mr. Speaker, was the first judge that I ever visited and did my first case before him at a court around the Bekwai area called Untado Court. So we don't doubt their competence. But Mr. Speaker, a precedent is being set, and this is dangerous for the nation. And that is why we oppose to this. Thank you, Mr. Speaker.
Honourable members, the proposal is that the minority has agreed that the leader will take the time yielded by the rest to submit for and on behalf of the minority caucus. On the majority side, my instruction is to allow 2 plus the majority leader. So the proposal is for the 2 from the majority to make their submissions, then the minority leader can then come in, and then we end it with the majority leader. That is the instructions I've been given. I want to hear from your side whether you are also ceding to the majority leader or you want to take your bite before the majority leader. Then we know what to do. Yes.
Mr. Speaker, the arrangement is that the 2 will speak, then...
No. Talk about your side. I've already stated what they told me. The rest have ceded their time to the minority leader.
Yes.
So they are not going to speak again.
Yes.
It's now left of your side.
Yes.
Would you want the 2 still to speak before you, or you want?
No. So the 2 will speak, then he will speak, then I will speak last.
That's what I said.
Yes. So they should go ahead.
So we'll take the 2 from your side.
Yes.
Then you now come in, then you will end up.
That is so.
Yes, that was what I put across. Yes, so who are the 2? Honourable Minister for Education.
Mr. Speaker, let me thank you for the opportunity to contribute to the motion ably moved by the first Deputy Speaker and Chairman of the Appointments Committee that this House approve the nomination of 7 justices of the Supreme Court of Ghana. And Mr. Speaker, in doing so, I just listened to my senior at the bar, who espoused and made reference to the Constitution and what the Honourable Animedu on what he considers best practice. Mr. Speaker, the question this House, guided by you, is to ask is 1. Is the President of Ghana, President John Dramani Mahama, legitimately and lawfully and constitutionally respecting the tenets of the Constitution? Yes, he has, and yes, he does. Mr. Speaker, may I refer you with respect to Article 1442. 1442. So President John Dramani Mahama is not doing anything than respecting the Constitution of Ghana, which in Honourable Afenyo's words and by his learning and training, the Court Norm of the Republic is the Constitution of Ghana. It reads, the Chief Justice shall be appointed by the President acting in consultation with the Council of State and with the approval of Parliament, not my interest. But Mr. Speaker, Article 1442, the other Supreme Court Justices shall be appointed by the President acting on the advice of the Judicial Council. Mr. Speaker, President John Dramani Mahama received lawful legitimate advice from the Judicial Council on the appointments of the 7 justices. In consultation with the Council of State, yes, there's been consultation with the Council of State before the President remitted the appointment letter. And then finally, with the approval of Parliament, this is what we are coming to do, Mr. Speaker. Parliament is coming to approve the nomination. So, Mr. Speaker, I speak in favor of the motion. And again, with respect, Mr. Speaker, I want to address the question raised by the Honorable Anyimedu. I may again, Mr. Speaker, refer you to Article 128. 128. Mr. Speaker, maybe you are now arguing today. 10 years back, it's always been my view that there should be a capping and ceiling of the number of Supreme Court judges. I even made a paper for CDD with Justice Pega then. But Mr. Speaker, what does the Constitution say today? President Mahama is not operating with an anticipated Constitution in the future. He is operating with the 1992 Republican Constitution, not a future Constitution. So, Mr. Speaker, if the argument by the Honorable Anyimedu and many of our colleagues is that seek an amendment to Article 128, that we have heard you, and that we all should resolve, must attract the attention of the Constitutional Review Committee, so that the Constitutional Review Committee in its work will consider providing for a capping, so that this question of whether 17, 19, 20, as he argued. But Mr. Speaker, Article 128 is crystal clear. It reads, and I quote for the record, the Supreme Court shall be due 1281. The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. Not less than 9. Not less than 9, mathematically, you did arithmetic. It means it can be more than 9. And 19 is more than 9. 20 is more than 9. Even 21 is more than 9. Judicial mathematics. Mr. Speaker, that is not to say I'm departing from a generally held view, which is my own view, that we should provide for a cap of a maximum of Supreme Court judges. But Mr. Speaker, until we review the Constitution, make fundamental changes to Article 128, the President is bound to respect the 1992 Constitution and its provisions. In any case, when you kept appointing justices of the Supreme Court, did you ever respect when the Ghanaian people said that lower, provide for a threshold? Today, because you are sitting opposite, you want to obstruct the right of President Mahama to appoint justices of the Supreme Court. Then, Mr. Speaker, finally, in the whole northern Ghana, Mr. Speaker, if there is a matter pending at the appeals court, they are compelled to travel to Kumasi and sometimes to Accra in search for justice. That should not be the case. That should not be the case. So not just the Supreme Court, even expansion of the Court of Appeal to the Upper West region, to the Upper East region, to the Northern region must necessarily occupy our attention. In conclusion, Mr. Speaker, one of the justices talked about demystifying legal education and expanding legal education. Mr. Speaker, even into next year, we will invite this House to make allocation for the expansion of the School of Law, supported by GET Fund. A request has been received by government through Professor Raymond Atuga of the Faculty of Law, and government is giving it good attention so that into next year we expand it, so that we train more lawyers. Now, Speaker, with these comments, I beg to support the motion that this House approve the nomination of those justices of the Supreme Court, because the President has only done what is lawful within the Constitution of the Republic of Ghana and what is within his mandate as President of the Republic to appoint justices on the advice of the Judicial Council and to go through the process of the Appointments Committee. Mr. Speaker, even finally, we are talking about asset declaration, and you are asking people, I've seen even arguments that members of Parliament, ministers should declare their assets publicly. Yes, if you want to do so, it's the right thing to do, but amend the Constitution. If you don't amend the Constitution as it is provides for the form and nature of asset declaration. If you do anything outside it, that's not acceptable. But to deepen transparency and to ensure that incomes that are earned by public officers, whether ministers or justices, are commensurate with their income, I share the view that there should be more openness in asset declaration. But as it is now, within the Constitution, we only can go through this audit service report. With this comment, Mr. Speaker, I support the motion.
Yes, Honorable James Agalga.
Mr. Speaker, I thank you for the opportunity to speak in support of the motion to approve of the President's nomination of the 7 justices as justices of the Supreme Court. Mr. Speaker, the eligibility criteria or the qualification for one to be appointed to the Supreme Court is stated clearly in Article 128 of the 92 Constitution. And the relevant provision, Mr. Speaker, is 128(4), which reads as follows. A person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proven integrity and is of not less than 15 years standing as a lawyer. Mr. Speaker, this is the eligibility criteria. And the committee, by a majority decision, found that the justices in question are all eligible. In fact, they are men and women of proven integrity and have met the 15 years minimum requirement at the bar. In fact, Mr. Speaker, I know most of the justices, and I will start with Justice Jamafe. Justice Jamafe has been at the Court of Appeal for 15 solid years. In fact, at the time of his nomination, he is the longest serving Court of Appeal judge. He has distinguished himself both as a judge, serving on the bench, and as one appointed by the President to serve on a commission of inquiry which investigated the 2014 World Cup and its related issues. Mr. Speaker, said Dennis Ajay, a distinguished academic scholar, lawyer of great repute, a justice of the African Court on Human and People's Rights, is a judge whose nomination for me to serve on the Supreme Court bench was long overdue. Long overdue. Same can be said about Justice Bill Suribari. These are justices, Mr. Speaker, I have appeared before in the course of my practice as a lawyer and can corroborate the findings the committee, the Ahiafo-led committee, has made. Mr. Speaker, the minority in this House opposed the nomination of the justices to the Supreme Court, and the grounds they canvassed for so doing are captured in the statement read by the minority leader, the Honorable Afenyo Makin. And I want to read excerpts of the statement he read before the committee. Quote, "We convene while our Chief Justice sits suspended through procedurally questionable processes under Article 146 and 296. An executive that suspends one Chief Justice while installing 7 new justices is not filling vacancies. It is reshaping the constitutional order. The appearance of institutional capture is inevitable and constitutionally catastrophic." And it goes on and on and on. Mr. Speaker, this particular statement needs to be interrogated. I do not understand exactly what the minority leader meant when he sought to argue that the suspension of the Chief Justice should be the reason why justices cannot and should not be nominated to the Supreme Court. Mr. Speaker, he rightly cited Article 46, which article contains the relevant provisions pertaining to the removal of a Chief Justice. And the entire statement he read before the committee, Mr. Speaker, he failed to point out which rule of procedure provided for under Article 146 was breached or violated. Article 146 is very clear with respect to the removal of a Chief Justice. With your kind permission, Mr. Speaker, I would refer to the relevant provision. 146(6). It reads as follows. Where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State nor members of Parliament nor lawyers. Then, Mr. Speaker, Clause 10 reads as follows. Where a petition has been referred to a committee under this article, the President may, in the case of the Chief Justice acting in accordance with the advice of the Council of State, by warrant signed by him, suspend the Chief Justice. So, Mr. Speaker, the procedure for dealing with petitions for the removal of a Chief Justice have been provided for explicitly. So the President takes receipt of a petition for the removal of a Chief Justice based on certain allegations. Then the President constitutes the committee envisaged under the Article 146. The committee, even before it settles down to work, some advice is sought from the Council of State. The green light is given for the suspension, and the President proceeds to suspend. Mr. Speaker, the minority leader says there are procedural breaches. Which of the procedures have been breached under 146? He failed in his statement to point out to the procedure which was breached. In fact, had the President refused or failed to suspend the Chief Justice, the President would have been in violation of Article 146, which violation could have formed the basis for his own removal, his own impeachment. He, the President, would have been the one who would stand accused for constitutional violations. So, Mr. Speaker, the point I am making is that the minority's leader's argument that justices of the Supreme Court should not be nominated or appointed merely because the Chief Justice has been suspended is not born out of the law and the facts. It's not born out of the law and the facts. Again, Mr. Speaker, the point needs to be made that if it is about filling the courts, and he talks about the systemic, he talks about what? The Supreme Court has abdicated its constitutional duty, blah, 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 repeatedly refusing to intervene. Mr. Speaker, suits were brought before the Supreme Court, and the Supreme Court dismissed the suits. An injunction application was moved before it, seeking to injunct the President from performing his constitutional mandate. And the Supreme Court said, no, you can't injunct the President from discharging his constitutional mandate. So the fundamental question to pose is, how did the Supreme Court abdicate its responsibility in this matter? Is it because a member from their side, the minority side, applied for the injunction application but was refused? Which is why they are now making the argument that the Supreme Court had abdicated its constitutional mandate in that sense. Mr. Speaker, several decisions were handed down by the Supreme Court. In most of the cases, the verdict was unanimous, 7-0, 5-0. We on this side never argued that the Supreme Court had abdicated its constitutional mandate. We criticized it on some of the decisions, the reasoning, but we never at any point stated that the Supreme Court, merely by sitting on a matter and declining to grant the reliefs sought, had abdicated its mandate. So, Mr. Speaker, with this, it is very clear that the statement that was made and the reasons contained therein for the decision taken by the minority to reject the nomination of the president clearly is not in conformity with the law. Maybe we can talk about the politics, but as for the law and the procedure, the president is not at fault. But, Mr. Speaker, if it is about the numbers, they talk about the packing of the Supreme Court. Let us refresh our memory. President Akufo-Addo, within 8 years, appointed 15 justices of the Supreme Court. 15! And all 15 justices of the Supreme Court were approved by this House within a period of 8 years. Mr. Speaker, whilst in minority, we never argued that the Supreme Court was being subjected, or the judiciary, to state capture. We never said so. Mr. Speaker, in respect of the Court of Appeal, President Akufo-Addo alone, within 8 years, appointed 48 justices. And yet, we did not talk about the capture of the judiciary. When it comes to the High Court, Mr. Speaker, the situation is even more alarming. President Akufo-Addo appointed 113 justices of the High Court. And yet, Mr. Speaker, we never accused President Akufo-Addo of attempting to capture the judiciary. So with these numbers, the appointment of 176 justices of the Superior Court of Judicature by their own former government, it doesn't lie in their mouths to finger President Mahama merely for nominating only seven justices of the Supreme Court. Mr. Speaker, 15 minus 7 is a huge number. And so, even before we get to the threshold where we can start talking about the packing of the Supreme Court, President Mahama has 8 more to go. 8. When he appoints 8 more, he would have equalized the number that was appointed by President Akufo-Addo. It is only when that happens that it will lie in your mouth to say, okay, let us cap it. Let's have a ceiling. Not until then, it is regrettable that you have refused to support the nomination of very distinguished jurists. All the nominees are justices of the Court of Appeal. In your case, we had a scenario where somebody was appointed from the High Court after having served for just a few months as a High Court judge. These are justices of the Court of Appeal who have distinguished themselves. In fact, they served on the High Court bench for so many years. Some of us appeared before them and can bear testimony to the fact that they made it to the Court of Appeal on merit and are proceeding to the Supreme Court once again on merit. Even me, as I speak, I qualify to sit on the Supreme Court bench. How much like somebody like Justice Dennis Ajay, a Ghanaian justice who on merit made us proud by joining the African Court on Human and People's Rights. We should be proud of justices of his caliber. So, Mr. Speaker, with these few words, I support the motion. Thank you very much for this.
Minority Leader.
Mr. Speaker, in honor of Justice Sophia Benasco Issa and Professor Richard Frimpong, I say, the ravening clouds shall not long be victorious, they shall not long possess the sky. Mr. Speaker, upon this foundation, I proceed to make my submissions opposing the decision or the motion before this House for the approval of 7 justices to the Supreme Court. Mr. Speaker, as I contribute to this report concerning appointment committee's report that vetted and is recommending 7 nominees to the Supreme Court of Ghana by majority decision, I want this committee to first acknowledge the diligent work and detailed work of those nominees that appeared before us. Mr. Speaker, without doubt, these justices distinguish themselves. But whilst we acknowledge the diligent work of the committee and the detailed report before us, I must, Mr. Speaker, address this House on matters of profound constitutional gravity that transcend the routine consideration of judicial appointments. The report already recommends by majority decision, but the circumstances surrounding these appointments demand our most rigorous constitutional scrutiny. Mr. Speaker, this is not merely another parliamentary debate on appointments. It is a defining moment that will determine whether we remain faithful guardians of Ghana's democratic heritage or become complicit witnesses to its systematic erosion. The very foundation of our constitutional democracy hangs in the balance as we consider this report this very evening. Mr. Speaker, I dare say that there is a constitutional crisis before us. Even as we debate these appointments, our Chief Justice sits suspended through procedurally questionable processes that make mockery of Articles 146 and 296 of our Constitution. Let us be abundantly clear about what we are witnessing. It is an executive that suspends one Chief Justice whilst simultaneously installing 7 new justices. Mr. Speaker, is this a routine feeling of vacancy? No, it is rather orchestrating a fundamental reshaping of our constitutional order. And it is the reason why, without any urgency, the report was laid today and government is in a rush to take this report and use its might in numbers to approve them. The confluence of events is neither coincidental nor constitutionally neutral. For the first time in our 4th Republican history, we face the spectre of wholesale judicial transformation executed under the shadow of executive overreach. The appearance of institutional capture is not merely unfortunate, it is inevitable and constitutionally catastrophic. The framers of our 1992 Constitution, in their profound wisdom,
establish a carefully calibrated system of checks and balances precisely to prevent such concentration of power. Article 144 requirement for Judicial Council advice, Council of State consultation, and parliamentary approval reflect deep understanding that judicial independence requires democracy's very cornerstone. Today, we must ask ourselves with brutal honesty, are we faithful stewards of their vision, or we are presiding over its systematic destruction? Mr. Speaker, the breathtaking hypocrisy of our friends in government is hereby exposed by their very conduct. As I stated at the opening of the vetting of the nominees, this government's hypocrisy reaches staggering heights that insult the intelligence of every thinking Ghanaian. The same NDC that relentlessly opposed the nomination of Justice Sofia Benasco-Issa and Professor Richard Frimpong Opon under President Akufo-Addo, crying incessantly that the Supreme Court was bloated, now presents 7 nominees simultaneously without a hint of shame or self-awareness. Whereas, where was their fervent concern about the court size when 2 eminently qualified justices sought appointments? Where were their constitutional principles then? This gross dishonesty and rank opportunism reveals an administration driven entirely by political calculation, not constitutional principle. When President Akufo-Addo nominated 2 distinguished legal minds, the NDC discovered urgent constitutional concern about judicial bloat. Now, with 7 nominees presented en masse, they miraculously find compelling constitutional necessity. Such breathtaking inconsistency exposes a government that treats our constitution as a political convenience, embracing principles when expedient, discarding them when convenient. This hypocrisy, Mr. Speaker, is not merely embarrassing, it is constitutionally corrosive. It demonstrates that the NDC government views judicial appointment not through the lens of constitutional fidelity, but through the narrow prism of political advantage. Such an approach threatens the very foundation of judicial independence and constitutional governance. Mr. Speaker, we must confront an uncomfortable truth about Supreme Court's recent conduct. When fundamental principles of natural justice face systematic violation in the Chief Justice's suspension, our apex court retreated into comfortable silence when constitutional courage was desperately needed. The Supreme Court's reluctance to intervene in manifestly flawed processes being used to remove the Chief Justice represents a troubling departure.
Honourable Minority Leader, please. The provision on relevance comes to play. Now you are addressing something which is different from what is before the House. You are addressing the issue of the suspension of the Chief Justice. What we have are nominees for you to give prior approval for appointment to the Supreme Court. So you focus on that one, not on the other issue. Please.
Very well, Mr. Speaker. We always take a cue from you. When confronted with the procedures that plainly offend constitutional principles, the constitutional timidity sends a chilling message about self-preservation over constitutional principle. Mr. Speaker, we ask, are these nominees going to add up to what we are already experiencing? Mr. Speaker, what is happening currently, which makes it curious for us to consider the additional nominee, is not merely disappointing, it is constitutionally inexcusable. The Supreme Court, where these nominees are supposed to join, does not exist to preserve its own comfort or avoid controversy. It exists to courageously uphold constitutional principles, especially when doing so is uncomfortable or politically inconvenient. The question is, are these nominees ready? Are these nominees ready? Mr. Speaker, we dare say that so far from what we have been experiencing, it appears that the court has abdicated its constitutional duty precisely when Ghana needs its protection most. What we have witnessed is an institution that has declined multiple invitations to exercise the courage required to restrain executive overreach. Are these nominees able to challenge executive overreach? The institutional cowardice, though perhaps humanly understandable, represents a fundamental failure of constitutional guardianship. The people of Ghana deserve better and expect these nominees to do better. They deserve justices who understand that judicial independence is not a privilege to be enjoyed, but a responsibility to be exercised with unbending resolve. Mr. Speaker, we in the minority, considering the circumstance of their appointment, whereupon the President wrote directly to the Judicial Council and even directed them to expeditiously consider his nominees, we find that it is such a rich circumstance that compromises the independence of these nominees. Mr. Speaker, the past procedure has always been that nominations will come from various interest groups within the legal fraternity. The Judicial Council will deliberate upon, make a recommendation to the President for the President to exercise his power of appointment. This is not what happened in this circumstance. Mr. Speaker, by these appointments, we hold a view that the doctrine of separation of powers is under siege. Separation of powers, details across chapter 8, 10, and 11 of the 1992 Constitution, is not an academic abstraction. It is democracy's immune system. When one branch accumulates excessive influence over another, the entire constitutional organism suffers. The independence of our judiciary is not a professional privilege granted to judges. It is fundamental right belonging to every citizen who seeks justice in our court. We dare again repeat, the circumstance of these appointments, are they going to live up to this expectation? Mr. Speaker, history teaches us that democracy Mr. Speaker, history teaches us democracy can collapse through dramatic military coup. However, in situations where there is a gradual capture of independent institutions by political forces, democracy also collapses. We must therefore vigilantly ensure that the highest court remains a temple of justice, not a forum for political convenience. Mr. Speaker, the then NDC in opposition said that there must be merits, there must be seniority in the appointments. What did we see? The same people who complain that in appointment to the Supreme Court, there must be seniority in the consideration. One of the judges said he's barely spent 2 years at the Court of Appeal. There are seniors at the Court of Appeal. So wherein lies the principles of the NDC? Wherein lies the consistency of the NDC? You attack the Akufo-Addo administration of not being fair. You had the opportunity. Did you address your so-called system of unfairness? What are you doing? Mr. Speaker, the sacred trust of constitutional guardianship is squarely in the hands of our judges. To the nominees who now await our final approval, let me say to you directly, you seek to join an institution whose legitimacy rests not on popular mandate, but on public confidence in your commitment to constitutional fidelity. If confirmed by the majority, which they are desperate to do, you will become guardians of our fundamental law. trustees of our democratic values, and protected of rights that belong to all Ghanaians, rich and poor, powerful and powerless alike. Do not be moved by the might of the government to ponder to them. Mr. Speaker, the Supreme Court's authority derives from its moral standing, not from political alignment. Citizens must believe that when they approach the court, they encounter justices committed to the law's supremacy, not to any earthly master. This confidence, once lost, proves extraordinarily difficult to restore. And this, I would want our nominees to think deep and reflect. To our nominees, I say to you, you will inherit a Supreme Court whose reputation, by virtue of the manner of your appointment, is being brought to question. Your duty is to weather the many storms and ensure that you pass the greatest test. Your task is not merely to occupy seats on that bench, but to elevate its standing through exemplary service that demonstrates judicial appointment based on merit, not malleability. Mr. Speaker, let me, in my further submission, proceed to address Article 125 of our Constitution. Article 125 declares that justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent, emphasis, independent, and subject only to this Constitution, unquote. This independence is not abstract. It must manifest in every decision, every interpretation, and every interaction with other branches of government. True judicial independence requires both institutional courage and intellectual humility. It means deciding cases based on constitutional text and sound precedent, not political preference. The government has created an impression that it is sending these nominees merely on the basis of political preference to the Supreme Court. This we don't need as a country. The judiciary must know that in protecting minority rights against majoritarian excesses, it has to deliver judgment that thoroughly, perhaps can disappoint its appointer, because the Constitution demands nothing less. Mr. Speaker, our colleagues made allegations of court packing, and this they used to physically prevent the laying of the report in the 8th Parliament. Today, what do we see? We see a genuine public anxiety about what the NDC is doing, which questions judicial independence. These concerns can only be dispelled through demonstrated commitment to constitutional principle over political expedience. True words spoken today and judgments delivered tomorrow. Mr. Speaker, we are, however, happy, in spite of our opposition in principle to these nominations, we are, however, happy with views expressed by each of the nominees on Article 66 of our Constitution. Mr. Speaker, each one of them expressed a genuine view on Article 66 during the vetting process. When confronted with their question, all 7 of them made it unequivocally clear that there is no interpretative ambiguity arising from its language. Their unanimous position that, quote, a person shall not be elected to the office of President of the Republic for more than 2 terms, end quote, means precisely what it says, no more, no less. It's constitutionally sound and reassuring. This provision admits of no creative interpretation, and any attempt to circumvent this constitutional limitation will represent judicial legislation of the most egregious kind. We pray that they will put their words into action when they eventually get it.
Honorable Minority Leader, once again, I remind you of relevance. The subject matter before us today has nothing to do with second term or third term of a presidential decision. Relevance. Let's deal with the issues.
Mr. Speaker, with respect, Mr. Speaker, ordinarily I won't challenge you. The report captures Article 66. Mr. Speaker, my submission is coming out of the report. The report captures Article 66. But I would abide by that, Mr. Speaker, if you... Mr. Speaker, I must remind our distinguished nominees of the solemn oath they took before expressing their views to the appointment committee. They swore to speak truthfully and honestly about their constitutional beliefs and judicial philosophy. The people of Ghana witnessed their categorical statement on Article 66, and they must not be seen changing these views upon appointment to the Supreme Court by the majority. Let me be absolutely clear. The constitutional commitment they demonstrated before the committee must remain unwavering throughout their tenure at the judiciary. Citizens can only have confidence if our judges who are before us today get the courage to consistently maintain the views they express at the appointment committee hearing. Mr. Speaker, we as a parliament stand at crossroads. Today, decisions we make today will either restore public confidence in our judiciary or mark the moment when Ghana's highest court became an instrument of executive convenience rather than constitutional conscience. Let me issue this clarion call to our colleagues opposite me, who are so determined and so desperate to go through this approval process. Mr. Speaker, what we have for them, we, the minority, will not join them in their inconsistent
You may continue.
We are not going to join them in their inconsistency in principle. Future generations of Ghanaians will judge their stewardship of our constitutional heritage and complicit in its erosion. They will ask whether we possess the courage to defend judicial independence when it faced its gravest threat, or whether we chose comfortable silence over constitutional duty. History recalls that democracies died not through dramatic collapse, but through gradual institutional surrender. Each compromise, each accommodation, each failure to resist constitutional violation contribute to democratic decay. We must not be the generation that chose convenience over constitutional principle. And we say that the majority is choosing political convenience over constitutional principle. Mr. Speaker, we have already stated in page 137 of the committee's report, and same can be seen in the final recommendation at page 138, With your leave, Mr. Speaker, I beg to quote. The committee, in conclusion, all members of the New Patriotic Party, the minority, were opposed to and voted against the nomination of all the justices on the grounds that, 1, the appointment of 7 justices was inconsistent with the NDC's own principle. We don't see it as filling vacancies, but we see it as reshaping a constitutional order at the very time that they have suspended the Chief Justice and they seek to dismiss it. Mr. Speaker, we also hold a view that the Supreme Court abdicated a constitutional duty and remained silent when fundamental principles of natural justice were violated. It is one of our reasons for opposing these 7 nominations. Mr. Speaker, again, we take the NDC by their own word. In the past, they said there was a judicial bloat. What has become of that argument? What has become of those 2 justices whose vetting was completed, the report was to be laid, and the NDC in opposition, in minority, physically prevented the laying of the report? And if I should quote, the then Chief Whip, quote, Mr. Speaker, I said, Mr. Speaker, if the majority lays this report, there will be chaos in the House, unquote. Mr. Speaker, our decision in opposing and voting against all the nominees is not against the person of these nominees. Unfortunately, Mr. Speaker, they are eating a forbidden fruit. The fruit, the tree that is bearing them is poison. It's a poison tree. And the fruit thereof, which is they themselves, cannot be edible.
Honourable Minority Leader, may you now conclude.
Mr. Speaker, I conclude by saying that whilst we stand to rely on the rules of this House to reject these nominees, we note that even the majority with their 187 on this day that they want to push through have not been able to commandeer their numbers. They don't even have the numbers to take a decision. And Mr. Speaker, at the right time, an application will be made to challenge them that they don't have the 138 to take decision, and they cannot take decision on this matter today. I so submit, Mr. Speaker. Thank you very much.
Honourable Majority Leader,
Right Honourable Speaker, let me start by making some basic corrections of some mistakes in the report. Page 1 of the report, line 2 of the executive summary mentions 6 nominees, but there are actually 7 nominees. and that error is also repeated in page 2, line 3. So just those basic corrections. So, Speaker, mine is not to bore the House with a very lengthy statement about matters that don't border on what is before us. So, Speaker, what is before us is the approval of 7 nominees to the Supreme Court. As a House, our basic responsibility is to find out whether the President acted in accordance with the Constitution or not. That's the first fundamental responsibility of the House. So, Speaker, Mr. Speaker, at no point has it been canvassed that the President has acted unconstitutionally. So the Constitution has been complied with. So, Speaker, the second set of questions that we ask ourselves would be the competence, the capacity, and the ability of the nominees. And Mr. Speaker, I have listened to the minority leader and members of the minority side who spoke before me, and they all clearly confirm that the nominees are very, very competent. Indeed, let me repeat what the report, which they agree with, says, that upon careful deliberation, the committee notes that all the nominees demonstrated outstanding competence, deep knowledge of the law, and a firm grasp of judicial ethics. They address questions posed by the committee with professionalism, clarity, and intellectual rigor, reflecting their capacity to uphold the independence, integrity, and dignity of the highest court of the land. Mr. Speaker, this is the testimony of the committee made up of both the majority and the minority members. This part of the report is not disputed. And they add that the committee is satisfied that the nominees possess the requisite qualifications, judicial temperament, and commitment to constitutional values expected of justice of the Supreme Court. So again, the questions that the minority leader raised about whether they can uphold the independence of the Constitution, whether they can uphold the balance that is expected of the Constitution between the legislature, the executive, and the judiciary, whether they can do that, that is equally answered by this paragraph, which says that the committee is satisfied. That is, the committee made up of the NDC and MPP members is satisfied that the nominees possess the requisite qualifications, judicial temperament, and commitment to constitutional values expected of justice of the Supreme Court. Mr. Speaker, on the basis of this, I don't think we should belabor the point about whether or not we should approve these nominees. They are obviously qualified, capable, competent, and will do the job. And I want to assure the minority leader that all the questions that he asked us have been answered in the report. Mr. Speaker, except to add a few things. My colleague, Honorable Agalga, has pointed out to this House that within the 8 years period, the NPP, led by President Nana Akufo-Addo, appointed 15 Supreme Court justices. 15. Appointed 48 Courts of Appeal justices. Appointed 130 High Court justices. Mr. Speaker,
after making all these appointments, in the dying days of his tenure as president, he anticipated that some justices will be retiring. And in anticipation that they will be retiring, he then brought nominations to this House in order that when they retire, he will still have the numbers that he wants to have on the bench. And as a minority, we took a position that we didn't know who will become the next president after Akufo-Addo. But we believe that Akufo-Addo had had enough opportunities to fill the Supreme Court. And therefore, since it was not the case that we didn't have the minimum number to constitute a bench, he should leave the situation like that until the next president assumes office and also has an opportunity to at least appoint the two nominees that he wanted to appoint. Mr. Speaker, this really was fundamentally the basis of the objection of the minority at that time. Nevertheless, Mr. Speaker, the minority joined the majority at that time, and we vetted the two nominees. We voted the same way they voted today. They voted against, or they are voting against the nominees. We also voted against the nominees, and they voted for the nominees. A report was written. The report was brought to this House. The only reason why the nominations didn't go through was that he, as majority leader, failed to have the report taken in this House. Mr. Speaker, I am holding a copy of the report. Mr. Speaker, 38th report of the Appointments Committee on His Excellency the President's nominations for appointment as Justice of the Supreme Court, September 2024. Mr. Speaker, the report was signed by no less a person than the person who sits today as the Deputy Minority Leader, Honorable Patricia Apiaje, who was then the Vice Chairperson of the Appointments Committee. She was the Vice Chairperson of the Appointments Committee, and she signed the report. And the report recommended that the matter should be decided by this House. And he was the majority leader. And he failed to bring the report for us to take it in this House to determine the fate of the two justices. Mr. Speaker, I am surprised and baffled that a person who had such an excellent opportunity to have the two justices, two nominees to the Supreme Court taken in this House, and who failed and refused to bring the report for us to take. Today, he sits and accuses the NDC for rejecting two nominees. We did not reject them. We voted against them at committee level, and you refused to bring the report. He failed. You failed. I'm surprised. I thought you would have glossed over that part of the history of this House, because that history is against you. Mr. Speaker, I was also of the mind that perhaps we should have fewer numbers in the Supreme Court. Mr. Speaker, I am being asked today what has changed. And I was influenced by the fact that most of my constitutional jurisprudence was taught me in the United States. So I am quite attached to the character of the U.S. Supreme Court, where we have just 9 judges. Mr. Speaker, this was my considered view. And indeed, And indeed, when the appointments committee sat, I vehemently canvassed that view. And the Honorable Apiaje was there. I vehemently canvassed that view. Mr. Speaker, until I came across a letter written by the current Chief Justice, who explained thoroughly and satisfactorily the need for us to reconsider our view on the matter. Mr. Speaker, Justice Tokono, the Chief Justice, the suspended Chief Justice, wrote a letter on the 14th of February 2024, signed a letter in her capacity as Justice Gertrude Saki Tokono, Chief Justice at that time. Mr. Speaker, it is an 11-page letter to the President, but I will confine myself to the last paragraph and read just that. Mr. Speaker, it says that it is for the above reason that the Chief Justice requests His Excellency the President to consider the appointment of an additional 5 judges to the Supreme Court to ensure the speedy resolution of cases and speedy delivery of final decisions for the nation. This should bring the current number of the Supreme Court to 20 judges. 20 judges, including the Chief Justice. This number will enable the setting of 3 undisturbed panels of 5, 2 panels of 7 or 9 judges to work on any set of cases on a given day, depending on the jurisdiction of the court being exercised in any given week, thereby reducing the specter of constantly reconstituting panels during a day sitting and its effect on pre- and post-hearing conferences. In that letter, the Chief Justice had made a very strong and compelling case why the Supreme Court should have not less than 20 judges. 20 judges. Mr. Speaker, after reading the letter, I became convinced that the court needs to have at least 20 judges. Mr. Speaker, so I'm surprised that the minority leader, who since a petition was lodged against the suspended Chief Justice, has been a key advocate for the suspended Chief Justice, has extolled her virtues, has indicated that she's the best thing that ever happened to the jurisprudence of this country. I'm surprised that one major recommendation that she makes, that the court should be constituted by 20, we should have 20 judges, that today he's opposing her recommendation. I'm surprised that you will go to such high heavens to extol her, and yet one key recommendation, one key legacy that she sought to leave, which is recommending that we should have 20 Supreme Court judges, that you will be against that. I'm surprised. But I can understand. Having failed to process 2, you cannot understand why we on this side will succeed in processing 7 on one day. I can understand. Unfortunately, it has to happen. Today, we will approve 7 nominees to the Supreme Court. Mr. Speaker, on that note, I urge colleagues to vote adopting the report. I plead with my colleagues opposite not to walk out. They should sit. Let us vote. I can see that in principle you are not against the nominees. You extol their virtues here, except that because you didn't succeed in approving the 2, you don't see why we should approve 7. But that is our luck.
That is our life. You have to live with that. Thank you very much, Mr. Speaker.
Honorable members, at the conclusion of the debate, the question is, as many as are in favor of the motion, say aye. Those against, say no. Honorable members, the ayes have it. The motion is adopted. This Honorable House has accordingly approved the nominations of His Excellency the President of the following persons as Justices of the Supreme Court in accordance with Article 1442 of the 1992 Constitution, respectively. Honorable members, the judges involved are Justice Senyo Jamafe, Justice Sir Dennis Dominic Ajay, Justice Biel Simon Surbare, Justice Philip Bright Mensah, Justice Janapari Ajwa Batels Kuju, Justice Hafisata Amaliboba, and Justice Kweku Tewia Aka Bofu. Honorable members, on your behalf and on behalf of the Parliament of Ghana, I congratulate the 7 judges for the recognition, for the public hearing, and for the prior approval given by this House. I recommend them into the hands of His Excellency the President to proceed to appoint these judges as Justice of the Supreme Court of Ghana. Yes, Honorable Habib.
Thank you, Mr. Speaker. Mr. Speaker, I struggled to catch your eye before you put the question. Mr. Speaker, and I want to draw your attention to Standing Order 139. And Mr. Speaker, I'm fortified by the Constitution in Article 104.1. Mr. Speaker, with your permission, I'll just read. Mr. Speaker, with your permission, I'll just read Article 104 of the Constitution. Mr. Speaker, except as otherwise provided in this Constitution, matters in Parliament shall be determined by vote of majority of members present and voting, with at least half of all the members of Parliament present. Mr. Speaker, I struggle to catch your eye. And Mr. Speaker, at the time you were putting the question, we were not up to 138. Mr. Speaker, we were not up to 138 to form a decision quorum. And Mr. Speaker, The decision of the voice vote, Mr. Speaker, in this respect, Mr. Speaker, however loud, it wasn't 138. Mr. Speaker, I struggle to catch your eye, but no matter how loud the yeah was, Mr. Speaker, Mr. Speaker, no matter how loud, I had done my counting, and before raising this issue, and Mr. Speaker, we were 128. Mr. Speaker, we were not up to 138 as a decision total. And Mr. Speaker, I invite you, Mr. Speaker, I invite you as a constitutional matter has been raised with regard to the decision that we have just taken. And I urge you, Mr. Speaker, to trigger the necessary process to satisfy Article 104 of the Constitution. Mr. Speaker, I so submit.
Honorable member, you have your standing orders with you. Do you have your standing orders with you? Do you have? Please kindly read Order 1262. Please, may you be on your feet and read the order to the hearing of everybody. Please, honorable member, be on your feet. Read
Mr. Speaker,
Order 1262.
Mr. Speaker, Order 162. 162. Mr. Speaker, Order 1262 reads, whenever the Speaker addresses the House, any member standing shall immediately resume the member seat. And the Speaker... Oh, let me finish. Mr. Speaker, I don't know. Mr. Speaker, they are disrespecting your directives. So let me read. Mr. Speaker, 1262. Whenever the Speaker addresses the House, any member standing shall immediately resume the member seat, and the Speaker shall be heard in silence. Mr. Speaker, Mr. Speaker, Mr. Speaker, Mr. Speaker.
Honorable members, please. Honorable members, can you, honorable member,
Mr. Speaker,
were you on your feet when I was addressing the House?
Mr. Speaker, I was on. Mr. Speaker, a majority with a lot of first-timers, that is how they behave. I can understand. Mr. Speaker, with respect, Mr. Speaker, you were making a ruling and I needed to draw your attention to a constitutional matter. So, Mr. Speaker, I was on my feet, and if I offend the others, Mr. Speaker, I know you are a father, and certain things you guide me, but I was drawing your attention to a constitutional matter. That's why I was on my feet. So, Mr. Speaker, if I offend you with this order, I sincerely apologize to that. Because, Mr. Speaker, it was not an address. I know that you were making a ruling, and I needed to draw your attention to a constitutional matter. So I didn't take it as an address, but I sincerely apologize.
Honorable member, what ruling was I making?
Mr. Speaker, the decision on the voice votes.
Is that my ruling?
Mr. Speaker, my understanding...
Your understanding of me announcing the decision of the House amounts to my ruling?
Mr. Speaker, I was on my feet before you announced the decision. So in your announcement, I wanted to catch your eye to draw your attention to a constitutional matter. And that they don't have 138. But Mr. Speaker, like I said, if I offend you, I apologize sincerely. But it was a constitutional matter that I was raising, Mr. Speaker.
Honorable Member, don't allow yourself to be misled by any person. I'm using your own answers to ask the questions. Using your own answers to ask the questions. So don't be misled by any person. I want to advise that in many of these situations, please don't react, respond. There's a vast difference between reaction and responding. You can cross-check. What we were doing was to react because somebody is misleading. Honorable members, with your kind permission, I want the First Deputy Speaker to take the chair. At least I need to, for health reasons, have at least stretch my limbs. I've been sitting for hours. In the meantime, is there any other business? Yes, Majority Leader.
Yeah, Mr. Speaker, if we can take 19, item 19. 19.
Honorable Minister for Interior. Honorable Minister for Interior, were you on a point of order?
Mr. Speaker, I was on a point of relevance. Mr. Speaker, our colleague, the Deputy Whip, was emphasizing and repeatedly was putting into the records of this House that at the time that he took the vote, the members in the chamber were around 120. Mr. Speaker, I can say in confidence, those of us in the chamber are more than 170. So it should not go into the record that we were less than the number 139 to take decision. We shouldn't let that stand in the record because the way he kept repeating it, if we did not challenge it, for it to be recorded in the official records of the House that it is not true that we were 120, it will stand in the record as though you did the wrong thing. And Mr. Speaker, I think you did the right thing. Thank you very much, Mr. Speaker.
Honorable members,